Hi, it's Debbie Baker. It's good to see you. Oh, that really were the case that I could see you. There's been stuff going on, and just recently I had a former client call and say, "What's happening?" And I spent 15 minutes telling him about all the sad things that have been happening in terms of people not getting their estate plans right. And it's fresh in my mind, and I want to talk about it. Might take longer than one video. Here's something that's happened 3 times just in the last couple of weeks. I've talked to people and they've told me they have their estate plans in place and that their wills say that Joe and Sally Jones, their son and daughter-in-law, their 2 children, whatever, will get their home when they die. And they're under the belief that that will keep them out of a probate situation because the will says that that's the case. Here's the sad news, is that it won't, at least not in Florida. Other states it might, in Florida it won't. When they pass, the will become of value, and they will have indicated that they want these children, both by birth or one by birth and by marriage, whatever, to own their home. But there will be a court action required so that the court acknowledges that and then puts that in place. And that would be the probate action. And it can be avoided. It can be avoided in a couple of ways. In Florida, there's something called a ladybird deed, which just gives somebody the right to keep their home with all of their homestead rights and all of their benefits from it, and can sell it, lease it, rent it, whatever they want without anybody else's permission. And then upon the death of the last life tenant, it's called, ownership automatically passes to whomever they've indicated. The indicated parties bring a death certificate to the county clerk, wherever that, whatever county somebody's died in Florida, at least, and title automatically passes without probate and without an additional tax consequence or anything like that. And people don't know that. Another way to do it is if you have a trust, you can make it part of the trust and it passes without probate. Only having it in a will won't do it. And it's just something to think about. If you have documents and you have that, and that's what you believe, do yourself a favor, call whoever prepared those documents and reassure yourself that probate won't be required in your state with your will in that situation. And if there's some way for you to ensure that your residence or any of your real property, rental property, goes to whomever you want to have without probate, just look into it. You just want to look into it. So that's one place. Another place is a woman who did her will. She adopted her granddaughter. The granddaughter's collecting Social Security. She named her brother to be the guardian of the child if she passed before the child became 18, which sadly she did. And she didn't have it in a separate document. And it's in the will. And the sad part about that is that probate has to be done so that the will gets, what's it called? Admitted. So the court admits the will, and I'm assuming, and I don't know because I haven't had this situation before, but the guardianship would come along with the admittance of the will. No reason that she would have known that, no reason that anybody would have necessarily said to her, do you want a separate guardianship document? And she set up a situation where probate is required because of this stuff. I've been at this now for 8.5 years, and I certainly haven't heard it all. And then I'm amazed at how little people really understand about getting it done right so as to save their I mean their family or their loved ones, extra grief when they pass. It's more and more of why, I've talked about it occasionally. I'm not in favor of do-it-yourself documents, because they're not customized and you don't have anybody to talk to about, if you fill this in, how's it going to work later? So, I guess that's enough. Just lots and lots of different situations. And for the sake of brevity, I'll cut it off here. We would love, meaning not even me and the cat, but me and the guy who does this video, we'd love to hear from you. We'd like you to like, comment, and share. You're welcome to call me. My company name and my phone number and stuff is scrolling across the bottom. I am happy. My consultations are always at no expense to you, just some time. And it doesn't matter what state you live in. I can only give specific information for Florida, and I can counsel for questions to ask if you live in another state, having given the caveat that I don't know your state law. Why don't you see what you can do? With that said, just have a great day. Talk to you soon.